Good morning, everyone. My name is John Rickzel Macalos, a student of PSHM3A, and I am here to report about the Philippine Tourism Law Chapter 3. And I hope that in the end of this report, I will be able to give you a clear insight about this topic. For our learning objectives, identify the different kinds of obligations and contracts, enumerate the ways of extinguishing an obligation, and enumerate possible application of contracts in the tourism, travel, and hospitality industry. For our topic outline, we have the law, modes of extinguishing obligation, and contract. Anyone starting a tourism, travel, or hospitality business must follow legal requirements and understand contract laws. Business agreements create legal obligation and breaches can occur. Studying obligation and contracts helps owners protect their rights, avoid legal issues, and manage disputes. This means that if you're starting a business in tourism, travel, or hospitality, you need to understand the laws that apply to your business and how contracts work. Business agreements create legal responsibilities, and if those responsibilities aren't met, it can lead to legal problems. Learning about these obligations and contracts will help business owners protect their rights, prevent issues, and handle any disputes that arise. For the discussion of the law, an obligation is a legal responsibility that one party has towards another, and failing to meet this responsibility can result in legal consequences. To break it down further, an obligation consists of four elements. First, we have the oblige. This is the person or entity that has the right to demand that something be done. They are essentially the party expecting performance, whether it's an action, payment, or another obligation. Second, we have the debtor. This is the person or entity who is responsible for fulfilling the obligation. They are the party who must take action, pay, or refrain from doing something depending on the terms of the obligation. Third, we have the prestation. This refers to the actual act payment for or forbearance, refraining from an action that the debtor must provide. It is the what of obligation, the thing that debtor must do or provide. And finally, we have the legal tie. This is the legal connection or bond that makes the obligation enforceable. It's what ensures that the debtor must fulfill the prestation. The tie is either based on law, like laws governing transaction, agreements, and etc., or a contract, an agreement between the parties. This connection gives the obliged the legal right to demand the performance and take action if the debtor fails to meet their obligation. Identifying presentation and obligation of the passive subject. Why it matters. Determining the presentation helps identify the passive subject responsible for fulfilling the obligation. Obligations to give a determinate thing when the obligation is to give or deliver a specific item. Deliver the agreed item. The debtor, the person responsible, must hand over the specific item that was agreed upon in the contract. Take care of it diligently. The debtor must take proper care of the item to prevent the damage or loss before it is delivered. Deliver all accessories and additions. If there are any additional items, parts, or accessories related to the main item, this must also be provided. Pay the damages if breached. If the debtor fails to deliver the item, take proper care of it, or provide the accessories, they are required to compensate for any damage or loss caused by the breach. Obligations to do. When the debtor is required to perform a certain action or a task. If not performed, it will be done at the debtor's expense. If the debtor does not carry out the required action, they are responsible for the cost of having someone else perform it. Incorrect work must be redone at the debtor's expense. If the work done is incorrect or not as agreed upon, the debtor must pay to have it corrected. Poorly done work must be redone. If the work is done poorly or does not meet the agreed upon standards, the debtor is responsible for fixing or completing the work to the proper standard at their own cost. In essence, these rules describe the responsibilities of the party who is obligated to either deliver a specific item or perform certain tasks. If they fail to meet these obligations, they must pay for the consequences, whether it's compensating for damages or paying for corrections to the work. Sources of liability for damages. Fraud refers to an intentional act where one party deliberately tries to avoid fulfilling their obligations and in doing so cause harm to another party. This could involve deceit, misinterpretation, or any dishonest behavior meant to manipulate or cheat someone. An example, if a business intentionally hides important information or makes false promises to avoid delivering goods or services as promised, they are committing fraud. Liability. If fraud is proven, the party responsible can be held legally liable for the harm caused by their actions. They may have to compensate the other party for any damages. Negligence. Negligence refers to a failure to exercise the level of care or diligence that is expected when performing an obligation. In a contractual setting, this is called culpa contractual, meaning the party failed to meet the standard of care required to properly fulfill their duties under the contract. For example, if a contractor is hired to fix a building and does so carelessly, leading to damage or further issues, this is considered as negligence. Liability. If negligence occurs, the party responsible may be held liable for damages resulting from their lack of care or attention to agreed upon work. In both cases, both fraud and negligence can result in legal liability. If a party either intentionally deceives someone or fails to perform their duties with reasonable care, they may be required to compensate the harmed party for any damages caused as a result of these failures. In short, fraud involves intentional harm while negligence involves careless harm. Both can lead to legal consequences in a contractual setting. Now let's talk about the Article 1231. There are other causes of extinguishment of obligation which are not expressly provided under the above provision. That extinguishes obligation which are purely personal and in character, such as partnership and agency. Obligations may also be extinguished by the happening of fortuitous event or by will of one of the party as in some contracts such as partnership and agency. Contracts, Article 1305. A contract is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or render some service. The essential elements of a contract are as follows. A contract is valid when both parties agree on its terms. This agreement happens when the person making the offer and the person accepting it are on the same page about what is being exchanged and why. The offer must be clear and the acceptance must be unconditional. The contract also needs to clearly define what is being agreed upon, the subject matter, whether it's a product, service, or action. Lastly, there must be a valid reason for the contract. The purpose behind the agreement should be lawful and clear. So, in conclusion, a valid contract requires three essential elements: mutual consent, a certain subject matter, and lawful cause. Consent is demonstrated through a clear agreement between the offer and the acceptance, where both parties are aligned on the terms. The subject matter must be clearly defined, and the cause behind the obligation must be lawful. Without these key elements, a contract cannot be considered legally binding. Here are also the characteristics of a contract. We have mutuality of the contracts. autonomy of the contracts, relativity of contracts, contextuality of contracts, and obligatory force of contracts. And that would conclude my report. Thank you so much for listening.